I want to introduce Jim Park. He's a professor of law at the UCLA School of Law. He's going to discuss his new book, The History of Securities Fraud Regulation, the Valuation Treadmill. And with that, I'll turn it over to you. Thank you.
Thank you so much, Ashley. Thank you, everyone, for coming out today, and thank you to Ashby for organizing this great event. I have been working on the problem of securities fraud for about 20 years in various forms. As I was telling the folks at my table, when I started out in practice in 2002, the collapse of Enron and WorldCom, which led to the passage of the Sarbanes-Oxley Act of 2002, were very much on the mind of everyone in the legal community, and it seemed like every week there was a new securities fraud scandal. And so when I went into academia and became a law professor, it was natural for me to think about that particular issue. So you may wonder, as CFAs, what do I need to know about companies and securities fraud? And I think there are a couple of reasons you might want to know a little bit about the issue. I think the first is simply that you are thinking about the risk of fraud when you are making investments and the risk that a corporation is misrepresenting something to you. And I think the second is that the perspective of a lawyer would be useful because the concept of securities fraud is sometimes a bit difficult to define and pin down. And so part of the book is not only telling the stories of various securities frauds over time, but also discussing the major regulatory developments in an understandable way, so that you have a better sense of what sorts of legal actions may arise out of a particular fraud. And so you may be better able to assess the risk of enforcement on some of your investments. And so I think the perspective that I bring from a legal perspective can be useful to this group. So just a very short lesson in terms of the basic law of securities fraud. This is a summary of a provision called Rule 10b-5, which some of you may have heard of, read about in the paper from time to time. This is what we call the Swiss Army knife of securities fraud regulation and enforcement. If you trade on inside information, you will be charged under Rule 10b-5. If you're a corporation that misstates or misrepresents something about its financial status or performance, Rule 10b-5 is the rule that the SEC will use to bring charges against you. So there are a few major elements of any Rule 10b-5 claim, a securities fraud claim involving a corporation. And the first is there has to be some sort of misstatement, some sort of misrepresentation by the company. Typically, this might be something like false financial statements that report higher revenue or profits than is warranted. And the purpose of that misrepresentation is usually to inflate the price of the stock, to increase the price of the stock or to prevent its decline. That misrepresentation must be material. It must be important to investors. Rule 10b-5 would not cover trivial misstatements, trivial matters that are not going to affect corporate valuations. And then finally and importantly, the misstatement must have been made with some fraudulent intent, some intent to deceive investors. It can't just have been a mistake. It can't have been mistaken information. The SEC and private plaintiffs who bring these suits have to prove that this was part of a broader scheme to deceive investors in some way. So I hope with this basic background, you'll have a little bit better understanding of the issue of corporate securities fraud. So what I wanted to do with this particular project was I wanted to look at major securities frauds over time in different eras. There are a lot of great books that look into a single securities fraud. Some of you may have read Smartest Guys in the Room about the Enron fraud. More recently, there's a book called Bad Blood about the Theranos fraud. But there's not really a book that compares and contrasts major securities frauds over time. And that's what I did with the book. Every chapter is organized around what I think of as an iconic major securities fraud that is representative of an era, starting from the 1970s. And by comparing and contrasting these different frauds, I hope to gain a better understanding of securities fraud and how the problem has changed over time. So why do companies commit fraud? Why do they misrepresent things to investors? A couple major simple stories that we see in these cases. The first is that you have a company that's trying to show that it's exceptional in some way, that it's growing very fast and it has very strong prospects for future performance. And so part of the reason it issues misstatements to investors is to show that it is growing. The second situation involves a company that was once great and once was dominant in some way, but it's trying to hide the fact from investors that it's in decline. It's in decline. So these are the two major stories that we see in these two types of cases. So a couple examples from the 1970s that show how these two theories work. The first involved a company that is located about 5 or 10 minutes from my house, or it was located 5 or 10 minutes away from my house in the Century City area. If you're familiar with Los Angeles, Century City is kind of our second downtown. It was a company called Equity Funding Corporation of America. It was an insurance company, and their fraud was fairly simple. They basically made up fake insurance policies that they claimed to have sold to individuals who did not exist. They had a separate office in Beverly Hills where they had about 20 people who their job was basically to fill out insurance forms to create these fake files. So when the auditors came to verify the insurance policies, they would have something to show them. To make matters worse, they reinsured the policies. They ceded the risk to reinsurers, which created obligations for them to pass on these premiums from the people who did not exist, which meant they had to create even more fake insurance policies in order to continue the scheme. So a very clear case of a fraud. And the observation of the bankruptcy trustee who looked at the company after it collapsed was that it was a securities fraud, right? This was motivated by a desire to show growth, to show the market that the company was continuing to grow its revenue and its earnings. The management team begged the CEO to stop. They told him, we're going to go to jail if somebody finds out we're doing this. And according to the report, the CEO flatly rejected the proposal to stop. He could not report a leveling of reported earnings. And this is what we're beginning to see in the 1970s or so, more pressure on companies to develop strategies that show growth or an appearance of growth in order to increase their stock price or maintain it. This was a shock because this is a New York Stock Exchange traded company, a reputable large company. And prior to cases like Equity Funding in the 1970s, the perception was that securities fraud is really a risk for small companies, right? Companies that are less reputable, that have less experience, less money to invest in internal controls. And so cases like this really show that the nature of securities fraud had changed as markets had begun to pressure companies to do more to develop, to report short-term increases in revenue and earnings. Another famous case from the 1970s involved Penn Central. Penn Central at the time was the largest railroad in the United States. It had been formed through a merger of the Pennsylvania and the New York Central. The Pennsylvania built Penn Station in New York City. The New York Central built Grand Central, to give you a sense of how significant those railroads were in our economic history. There's a lot of concern about the merger, that it would create a company that was too big to fail. But the merger was also motivated by weakness, because by the 1970s, you have the interstate highway, you have cheaper air travel, and so railroads are facing pressure with respect to their core business. And so Penn Central was desperately trying to show that it was turning around its core business and that it would be able to survive as a going concern. And so one of the things it would do to generate more revenue and earnings was to sell assets, property, other assets it had purchased in better times. And there's nothing fraudulent about a strategy like that. You are permitted to sell assets to generate revenue and earnings. But there were a handful of transactions that were questionable in the way that they were reported. One of them involved Six Flags amusement park that was located in Texas. So Penn Central sells the amusement park to a partnership of investors for about $29 million. And they also had a side agreement with the investors. The investors didn't want to take on the risk of loss with respect to the asset. They had some tax reasons for investing in the amusement park, but they didn't want to lose money if the value of the asset fell. And so in order to make this transaction go through, Penn Central enters into a side agreement saying that we're going to keep the risk of loss on the asset. And the reason why that's problematic from an accounting perspective is that if I'm selling something, I should be selling all the rights and obligations associated with that asset. If I'm keeping the risk of loss, then there's a strong argument I should not be able to count this as a sale. And so that $29 million should not go into my revenue and my income. This was a tactic that Enron used decades later. They had all sorts of different assets that they would sell to special purpose vehicles to get them off the books. They would keep the risk of loss, essentially, because they were ultimately accountable for the SPVs if they went under. And that was a reason why a lot of the transactions Enron entered into with the SPVs should not have been reported as revenue on the company's financial statements. What was the defense of the company and its auditors? The auditors, they didn't try to defend the propriety of the sale. They didn't try to say that it was a real sale. Their argument was it's not material, right? Recall one of the elements of Rule 10b-5 is materiality. And they said it's a $29 million transaction. This is a multi-billion-dollar company. Why would it matter to investors that Penn Central inflated its income by $29 million. It's an accounting professor, Abe Brilloff from New York City, who taught at Baruch University for a long time. He writes a very interesting column in Barron's, and he makes an interesting point, which is that, well, the reason it was material was because this was a period when Penn Central predicted they would have a favorable showing, right? They had a projection that we were going to have a good year. Without this transaction, they would have reported a loss instead of a small profit. And so the motivation was to meet this projection. And all of you are familiar with the quarterly ritual now of assessing whether or not a public company has met its earnings projections and the pressure on companies to show that they are meeting prior analyst predictions of their performance. And this is what I'm talking about when I refer to the valuation treadmill. Right, just maintaining your valuation requires sort of running through this treadmill continuously of meeting expectations and setting high expectations for growth. And that, to me, is what makes securities fraud a significant risk for many public corporations and why we need some regulation in order to assess the risk of securities fraud. By the 1980s, we see a different theory of securities fraud that's a little bit more controversial than some of the cases that were brought in the 1970s. By the 80s, we see the computer industry booming. And so there are a lot of these tech companies that are valued based upon the prospects of maybe one or two products that they're developing. And to the extent that there's bad news about the development of a product, the stock price of these companies could fluctuate quite dramatically, which creates an incentive for the companies to delay the release of bad news about a product. So a famous case involving this theory was filed against Apple Computer before it became the world's most valuable company. It was a newly public company that was trying to show it was not a one-hit wonder. It had developed the wildly successful Apple II that essentially launched it from an operation running out of a garage to a $2 billion public company. And so their strategy was to develop a computer for the office market, and they called it the Lisa. And one of the features of the Lisa is it had a high-performance disk drive called the Twiggy. And this is the day before we had cloud computing and large hard drives. You had to put all your programs on a disk and put it into a floppy drive. And so they issued a number of statements, press releases about the product, which are replicated here. And the gist of the statements was that, the product is done, we've tested it, we know it is superior to other disk drives. That's the gist of the press releases. In fact, the Twiggy was not finished. It had a bunch of flaws, and Apple had to discontinue the product. The stock price goes down by about 20% once the product was discontinued. Investors got upset. They filed a lawsuit in federal court alleging securities fraud. So the plaintiffs basically argued that Apple did not tell the full truth about the Twiggy. They had internal memos written by people within Apple. At the same time, Apple was making fairly optimistic statements about the product. The engineers are saying, we're going to need to delay the launch of the product. It has too many flaws. Steve Jobs, who had been kicked off the Apple project to work on something called the Macintosh, says he has virtually no confidence in the team working on the Twiggy. The defendant's response, and I think this is actually a fairly good response, is that this is just how product development works. There's always a fire drill at the end. You never know for sure until the very end whether it's going to work without problem. And if you make us liable under Rule 10b-5 for misleading statements in the situation, you are going to deter risk-taking. You're going to deter entrepreneurship if we're not able to make positive statements about our products. What company can really survive without some optimism? And that is the fundamental debate here. And I think there are good arguments on both sides. This is a bit more of a controversial theory of securities fraud than, say, equity funding, where I think everyone would agree, making up fake insurance files is bad, right? That is fraudulent. Here, we have a bit more of a questionable theory of securities fraud. The jury ends up agreeing with the plaintiffs and awarding $100 million to them, although that verdict is reduced on appeal. It sends shockwaves through Silicon Valley, and a law is passed in 1995 that makes it a bit harder to file these types of lawsuits. So it's a controversial theory, but it's a theory that's alive and well today, and even in the criminal context. Back in November, you may have heard of the conviction of Trevor Milton, the founder of a company called Nikola, which was developing, still is developing, semi-trucks that run on hydrogen. He was convicted of criminal securities fraud in the Southern District of New York. And if you look at the sorts of things that were the basis for that securities fraud claim, it's not all that different than the statements made by Apple. It's fairly optimistic statements about the product and its development, their technology, different orders that they have. These are the basis for a criminal securities fraud action, and it's essentially a theory of misrepresenting the status of your product and your technology. Now, one of the things that may have gotten the attention of prosecutors, as some of you know this story, was that one of the statements was that we have a prototype that can be driven. The prototype was not ready, so they film the truck. They take it to sort of an incline, and they kind of push it down the incline, and they film it kind of rolling down this hill and put it on YouTube and say that, well, this shows that our product can be driven. It was not drivable at the time. So I think maybe part of the reason prosecutors went after Trevor Milton was that he was targeting retail investors with misleading information, and he was doing it very consistently. He did it on multiple occasions as opposed to single, isolated misstatements. But if you think about the Theranos case, right, Elizabeth Holmes, she claims that she has a machine that can run multiple tests on a single drop of blood. They don't have that machine. Criminal conviction of securities fraud. Interesting that Steve Jobs was Elizabeth Holmes's role model and hero. By the 1990s, we begin seeing quarterly projections becoming more important. In the 60s and 70s, projections were made more on a semi-annual or annual basis. We see dozens of cases by the 1990s involving companies that violate accounting rules in order to move revenue forward in order to meet these projections. Example involved Xerox, one of the most iconic U.S. companies, inventor of the plain copy paper copier. In the mid-90s, they moved billions of dollars in violation of generally accepted accounting principles to earlier periods. The reason they did this, the SEC says, was to meet various expectations in virtually every reporting period from 1997 through 1999. So the typical defense in these sorts of cases, and it's a valid one, is that the executives will usually argue that, we're not experts in GAAP, right? We're not experts in accounting. We did what our auditors allowed us to do. And so we don't have fraudulent intent. We don't have the intent to deceive anyone because we just made a mistake. We made a mistake in moving the billions of dollars of revenue forward. They might say, we're not as bad as like equity funding. We didn't make up this revenue, right? This is revenue we were fairly confident we were going to earn. We just might have recognized it earlier than appropriate. And so in these cases, what the SEC is looking for is fraudulent intent. And what was the purpose of the GAAP violations? Why were they doing this? And the story the SEC tells is that, this is part of a broader corporate narrative. This is a copy of a front-page Wall Street Journal article from around the period of this fraud. And the CEO is basically giving interviews and saying, we're beating back the digital revolution. This is the time of the internet. As the internet's coming in, you have less need to make copies. You can just email a PDF of a document to your colleague. You don't have to make a physical copy anymore. But Xerox's CEO is saying, we're still growing. We're still doing fine. And he's pointing to double-digit U.S. revenue growth in support of the theory of his story, that Xerox is still a strong company. And without the accounting violations, he could not have made the statement because the company would have reported flat growth. And so this leads the SEC to penalize Xerox $10 million, which at the time was the largest SEC penalty. And I think this reflected the growing recognition by the SEC of these pressures to deceive investors by misstating corporate earnings in order to meet quarterly projections. Enron was another case in this vein. Except it was criminal rather than just a civil case. And I'm often asked, why was Enron criminal? Why was there a criminal prosecution in this case? And it's not an easy question to answer. What makes securities fraud criminal? What makes it civil? And it really depends case by case. I can give you a basic explanation of what I think was going on in the Enron case and the prosecution's theory. And I think one of the interesting things about the Enron criminal case is that, as you know, Enron was a multi-billion-dollar accounting fraud. Billions of dollars moved off the books improperly to special purpose vehicles. That created the appearance of less debt on the company's balance sheet. Part of the reason they may have done this was to keep a high credit rating because they're trading in energy markets and they need that credit rating. The prosecutors, though, are focusing on smaller misstatements. And this is a list of some of the misstatements that were considered on appeal. And you have some larger ones of $500 million, but you have a $7 million misstatement, a $12 million misstatement. And one of Jeff Skilling, who was the prosecuted CEO, one of his defenses was these are foot faults, right? These are small misstatements in the context of what was a $70 billion company with a $70 billion market capitalization. And so why did they focus on these small misstatements? Well, one reason, I think, was that even though they were small, they were significant because they allowed Enron to meet earnings targets. And so there's this notorious transaction involving the sale of Nigerian barges in Nigeria to a special purpose vehicle. And the prosecutors alleged the reason they did this was to meet an earnings target at the end of the quarter, right? And so we go back to that Penn Central case and this theory of materiality. 20, 30 years later, it's kind of showing up in a criminal case, right? And the motive of meeting an earnings target was seen as sufficient to show that the misstatement was material. We also see Jeff Skilling personally involved in the improper transaction. So he couldn't argue he didn't know about it. He went to Andy Fastow, who was the CFO in charge of the SPVs, and he allegedly guaranteed to Fastow that he's not going to lose money on the transaction. He's kind of guaranteeing him that I will make sure you're not going to lose money. What's improper about this, again, going back to Penn Central, if I'm selling an asset, right, I have to sell the risk of loss along with it, or I cannot recognize that revenue. And so what we have here is we have the CEO personally involved in the transaction and also involved in the aspect of the transaction that arguably makes it fraudulent. Very hard to construct cases like this, a lot of effort, a little bit of luck as well. And I'm often asked, well, why weren't there more criminal prosecutions after the 2008 financial crisis? Why didn't they go after the CEOs of the big banks? They just didn't have this kind of evidence. They didn't have evidence of the granular knowledge of particular transactions. They didn't really have evidence of personal involvement in making these transactions fraudulent in some way. Major response to the securities frauds of the 1990s, as you know, was the Sarbanes-Oxley Act. And one of the things Sarbanes-Oxley does is it strengthens expectations surrounding internal controls over financial reporting in companies that are public over a certain size. And that's essentially an obligation to prevent misstatements and securities fraud. Interesting guidance by the PCAOB, which is a regulatory body that governs auditing, that was formed by Sarbanes-Oxley. And when they talk about these internal control reviews by auditors, they really emphasize projections, quarterly reporting, unusual transactions, at period-end financial reporting. And so we begin sort of seeing that the influence of these projections has influenced the way we look at the law, the way that the SEC and auditors are looking at public company auditing and accounting. And so this is a slow process, right? The grains of the theory the seeds of the theory are planted in the 70s. Over time, we see them influencing and becoming regulation and regulating public companies. As you know, Sarbanes-Oxley is a controversial law. And I know there are good arguments on both sides. There's some who say that it's too burdensome on public companies, creates incentives to not be public, and we're over-regulating. I think the counter-response, though, is that, with pressures on public companies, to be a public company is, it's not your right to do so, it is a privilege. And in order to be a public company, you should be meeting obligations to have strong internal controls so that markets can value you in a fair way. So we're seeing fewer of these outright securities frauds in terms of accounting violations, but we're seeing the SEC shift a little bit to other types of practices where you're not necessarily violating an accounting rule to meet your projections, but you may be changing your business decisions in order to manage earnings. And the SEC has filed a case or two that sends a message that this can also be deceptive and fraudulent. One notable case is against General Electric a couple years ago. The SEC required them to pay $200 million to resolve a case that they had filed. As some of you know, back in 2017, GE reports massive losses in healthcare and power businesses. The stock price goes down by about 80%. More is lost by investors in GE than Enron and WorldCom combined. A huge shock to an iconic American company. So what did GE do? What was the SEC penalizing them for? Well, they didn't violate accounting rules, but what they would do is they would manage their business to meet projections. And one of the things they did in their power business was as they were kind of running short on cash, they would sell receivables, money they would receive in future years in order to generate that cash today. And so their past practice was that they would typically sell receivables of about a year out. As they got a bit more under pressure, they would sell receivables with due dates up to 5 years out. And there's nothing objectively wrong in terms of accounting rules, in terms of doing this. Is sort of a business decision. If I want to sell my receivables, I have the business discretion to do this. The problem, though, is it does make the company more risky because you do have to make up those receivables, right, in future years. If you don't, then you may have to report a larger loss at some future time. And in the 1990s, GE was praised for doing things like this, for smoothing its earnings, as you know. And this is another front page story in the Wall Street Journal about, GE, smooths its earnings, it damps fluctuations. This is an open secret. And so it's interesting to see the SEC 20 years later filing a case saying that actually this is violative of SEC regulations. So I think there are a couple things to highlight in what the SEC says was wrong with what GE did. And I think the first was simply that they knew that analysts were looking at these cash flow numbers. And this was meant to meet cash flow targets that analysts had set for the power business. So again, we're looking at projections and efforts to meet projections improperly. Secondly, and importantly, the SEC alleges that the executives of GE just knew this was not sustainable. They knew it was creating a misleading portrayal of the company and its business. And so that was their basis for bringing a case like this against GE. Also a bit of a controversial case. A lot of courts have said that this type of real earnings management is not fraudulent, that it's not a misstatement or misrepresentation because you're just making business decisions. You're not violating GAAP. Right? With GAAP, you are making, if you're violating GAAP, you're making a misrepresentation because every public company commits to filing financial statements that are in accordance with GAAP. There's no similar outright misstatement that the SEC can point to in this case. So also a bit of a controversial theory. All right. So, fast forward to recent events. I wanted to just speak very briefly about the FTX scandal because it does have a securities fraud element to it. And as you know, Sam Bankman-Fried is being criminally prosecuted in the Southern District of New York. And if you look at the criminal indictment, one of the counts involves an allegation of securities fraud. FTX, the cryptocurrency exchange, raised about $1.8 billion in private placements from private investors. And whenever you sell securities across state lines, you are subject to Rule 10b-5. And so if you've misled those investors in some way, this can become a securities fraud type of lawsuit. So what is the theory of the case? Well, in making these sales, they are making representations, various representations to investors and the general public about their ethics, their ability to manage conflicts of interest, their protection of consumers, segregation of consumer assets. So with any major corporation, you're making representations constantly, and those representations, to the extent that they are material misrepresentations made with fraudulent intent, can violate Rule 10b-5. So these are the misrepresentations that the criminal prosecutors are pointing to in their complaint, because in fact, as some of you know if you've read the stories, there was massive commingling between this crypto exchange FTX and Alameda, which was a hedge fund also started by Sam Bankman-Fried. The hedge fund had access to the bank account where customer accounts were deposited, and they essentially used those funds to speculate on cryptocurrencies. Also, they used it to pay back loans that were being called as the crypto market entered some turmoil about a year or so ago. And so the argument is because of this commingling, because of this conflict of interest, the statements and representations that FTX made to investors were materially false, and no investor would have invested in FTX if they had known about the commingling that had happened. So you almost always see the potential, at least for a securities fraud claim in these major corporate scandals, because it's necessary in a company's life to raise funds from investors, whether it's through private placements or more public securities sales. One other point to make is that the other area I see the SEC getting more active in interesting ways is the ESG front. No doubt you've been talking about environmental, social responsibility, and governance considerations. It's the hot new trend. Whether it will continue is really up to you investors, quite frankly, because the reason regulators are paying attention to this is because the investors are, and the SEC is the investor's advocate. So this is a case the SEC filed against a Brazilian mining company. And they had a dam collapse in Brazil, which caused significant amounts of environmental damage and loss of life. They had ADRs trading on the New York Stock Exchange. The price of the securities go down. Not only do they have to deal with Brazilian environmental regulators, they have an SEC lawsuit on their hands. And the SEC says you didn't really forthrightly disclose the risk of an ESG disaster. So this is the type of case that the SEC has brought, not infrequently over the last 4 or 5 years, and I expect they will continue to do so. Right? Similar cases against Boeing, McDonald's, and so forth for corporate scandals. And if you read Matt Levine, the Bloomberg columnist, he has sort of this running joke about how everything is now securities fraud. Whenever something bad happens, somebody says, well, you didn't tell us about the risk of this scandal and we were defrauded. And there's a certain grade of truth to that. But in the SEC's defense, they did uncover a lot of evidence that this Brazilian company, Vale, they had done a lot of internal risk calculations on their dams. And they had discovered internally that there was a high risk of collapse, or higher than acceptable risk of collapse. Yet in their various disclosures, they had sustainability disclosures they were making to investors. They say our dams are safe. And so you can think about that for yourself. Is that deceptive? Is that a material misstatement when internally your dams are probably not safe, there's a high risk of collapse, and yet you're making statements to investors who are demanding information about the dams and claiming that they're safe? Is that something that should be allowed for public companies? That's something that's still being debated. It is a bit more of a controversial theory, but part of the point of my book and my argument is that the concept of fraud changes. It evolves over time as public companies change and the environment within which they operate changes. And I think this is kind of a nice example of how those theories have changed over time. Thank you so much for your time. And I have a little bit of time left for questions if anybody has any questions about the presentation or other elements of securities fraud. Ashby.
A question with Silicon Valley Bank. They were audited about a month or a month and a half before the collapse.
Yeah.
Do you think that could be potentially be considered fraud? And are there any cases right now?
They certainly are being investigated by the SEC and the Department of Justice. It will depend on looking very closely on their public statements in the weeks leading up to the collapse and their knowledge at the time those statements were made. And one theory I've seen floating around was that at some point they know Moody's is likely to downgrade their credit rating. And they're making certain statements after that. Could that be seen as a misrepresentation? Now, I think their defense, though, would be that in a situation like that where their solvency is in question, shouldn't they be allowed to reassure investors? Shouldn't they be? Was their intent to really deceive them in some way versus let's try to manage the storm a bit, right? I think that's kind of the difficult question that regulators would have to answer. My inclination is I probably wouldn't think of that as a fraud myself personally, and I think that's why the banks were not penalized as much for securities fraud for the 2008 financial crisis, where there's this unprecedented economic turmoil. They're just trying to manage their way through it. But there certainly could be evidence that comes to light that makes the SEC do something. So, but the separate issue of auditors is that always comes up. FTX as well. Where were the auditors, right? Where were the auditors in this? And that's certainly an ongoing issue. When I speak to auditors, what they often say is, look, we're not forensic accountants. We can't go in and look at everything within the company. We're just trying to assess, are they meeting generally accepted accounting principles? And so there's debate about, what do we expect of auditors? They have a view. I think investors may also have a view as well. It's also a very interesting question that's raised by securities fraud. Yes, Matt.
James, is there anything in either in published research or in just your kind of anecdotal thing? It seems like a lot of these frauds are reactive, right? So it's like the business deteriorates.
Sure.
It's not like somebody walks into this and is like, I'm gonna steal everyone's money.
Yeah.
It seems more like the sands of time will change underneath their feet.
Yeah.
And then they're like, how do we react to this? Any sort of thing you could share about that? Is that generally the case where?
It's a great point. I think that, we have to recognize, I think the SEC should recognize it's tough running a public corporation and navigating distress. And you can make that argument even of FTX. And Sam Bankman-Fried might say, I just made a mistake. I screwed up when the market's collapsing. I have $10 billion of assets at one point, now it's $1 billion. I'm just desperately trying to do something, and I just made some mistakes. I think the argument on the other side, though, is that you're running a public corporation these days. It's very serious, right? And there are regulatory obligations, and I think that there's certain things you just do not do, right? And so I think that's what we have to trust enforcers to do good job of, is kind of identifying those cases where you cross a line in some way, right? You cross a line in doing something that is clearly problematic and wrong, versus those folks who are making mistakes in the pressure of the moment. And I think that's, what I think, studying the history of securities fraud regulation, part of the reason I wrote the book was to kind of, give people who are enforcing these laws kind of a broader perspective of how they should look at cases like this, and not just assuming just because the business failed there is a fraud.
As a practitioner, I always catch myself saying, like, are they lying to us, or are they just incompetent? Right? I mean, Either one is flattering, but one is illegal and one is just.
That's right.
Yeah.
That's right. And incompetence is not securities fraud.
Right.
It's something that, but it's hard to draw that line. Yes, sir, in the back.
You mentioned something about sort of ESG and that example with the Brazilian mining company.
Yeah.
One major distinction between a lot of the ESG disclosures companies make and financials has to do with that kind of voluntary disclosure versus mandatory.
Yes.
Do you think that kind of concerns about greenwashing, and you mentioned that as a growing area, but do you think that companies can still be on the hook for voluntary disclosures? Is that something that really made a difference to investors trying to put a story that's just not accurate or whatever the case might be?
Yeah, I think so. I think so, and I think companies should be aware that just because it's a voluntary disclosure doesn't mean that it's not going to be scrutinized. And I think lawyers often advise companies, if you're making these disclosures, make them very vague, or make them as vague as possible to reduce the risk that it's seen as a misstatement or misrepresentation. But the SEC doesn't necessarily buy that argument. Some of those statements they point to in this volley case are very vague statements about general safety, right? And so I think that, the interesting thing is courts, when they hear these cases, often say that those vague statements are not actionable. And so there's going to be a real debate about what exactly is fraud in this particular context. But I think the SEC feels like if it's going to be serious about ESG, it has to be serious about ESG enforcement. And so there is pressure on them to move in these areas for better or worse. And so we're going to see a lot of new law. Now, with greenwashing, I think the place where I think the SEC will be a little bit more hesitant is when there's not an economic loss associated with the statement. I think that's where I think they're probably going to be more hesitant, even though they're being urged by a lot of folks to kind of bring more greenwashing type cases. Unless they can kind of point to clear economic harm, I think they're not as likely to bring those cases, but they could start bringing them to make a point. And they have various tools they can use to do that. Yes, sir.
I want to add on to that. Sorry for answering instead of you. I'm a public company general counsel. I spend a lot of time with other public company general counsels. This ESG thing is huge for all of us, and a lot of it has to do what are the standards that are currently being reported, and are they auditable? And a lot of companies that are younger ESG reporting are finding it easier because you're kind of starting from that audited stance. A lot of companies that have been producing ESG reports through their marketing departments for years are now having to go back and eliminate a lot of disclosures going forward.
Interesting.
Because they're saying, and they have actually been right, people believed in When an auditor comes in, you can do it, and so we can't report on those things. So we've got a lot of other general counsel that are scared and cutting back on the ESG reporting because of that, and really only going to what can you audit, what's reproducible each year in an annual report, the same calculated methodology, et cetera.
It's fascinating. Thank you. Thank you for that. Love to talk more if you have time. All right. Well, Tom, did you have a last question? I thought I saw your hand up earlier.
You know, we see when a stock price goes down 20% in a day, by the afternoon, you get 3 or 4 press releases from lawyers saying, you know, we're filing suit.
Yeah.
We have
Yeah.
investors.
Sure.
It's
Sure.
kind of securities fraud, ambulance chasing in my
Yes.
mind.
Yes.
What happens to those situations? Is that just
Yeah.
a method of getting documents, or is it blackmail?
Yeah.
Is it, what is it?
A little. I mean, it's part of it is that the attorneys are trying to kind of, get the clients in place, and I think if they have the complaint in theory, they're more likely to get somebody who suffered a significant loss on board. But courts have gotten pretty good at weeding out cases at an earlier stage where there's just no basis for fraud. And so the stock price drop strategy is a risky one for the firms, but it does cost money for people to defend these cases. You got, a couple hundred of these filed every year. Maybe you get half of them dismissed at a fairly early stage, but another third of them, another half of them may continue, and maybe a third of them result in some type of settlement. So it's a real cost on public companies, and so it's something that judges have to be aware of those costs and do a good job of weeding out the bad cases. But you're right, there is a huge industry that's arisen out of this, and so I think that's an issue. Matthew?
Yeah, just, Thomas, first of all, ambulance chasing is a spectacular. I was just, you sort of hinted to this before, but I was using Thomas's example as an example. It always seems like these things are after mergers and capital raises, right? So it's like these guys go out, do an IPO, and then the first quarter out of the box, they miss numbers, and everyone's like, whoa. Like, is that a specific case when there's a recent offering or a transaction? Or is that just
well, part of it.
Underbelly that's the easiest.
Yeah, I mean, and part of it is that the laws, the securities fraud laws governing, recent offerings are very, very strict, and they're really harsh for various reasons, and that's why it's easier to win claims under those laws. The merger stuff was a big problem, although I think states like Delaware have tried to cut back and find ways to dismiss those cases early on. So thanks so much. I hope you have a chance to check out the book. If you want to pick up a copy today, I have a few with me as well. Thank you so much for coming.
And if someone wants to buy your book, can they find it on Amazon?
It's up on Amazon as well.
Okay, well, great. Well, Jim, thank you so much, and everyone, I appreciate your attendance today. And as always, thank Ellen as you go out. She's the one who coordinates all of our luncheons. So thank you very much. Thank you.